Good afternoon. Welcome to Best and Krieger's webinar series titled From Code Compliance to Fighting Fire Traps, How to Deal with Dangerous Dwellings in Your City. We will get started in just a few minutes. Before we begin, we have a few housekeeping items to go over. As a reminder, please note that all attendees are in listen-only mode. If you have any questions during the presentation, please use the question box in the lower right-hand corner to ask questions. If you wish to view and/or print the presentation materials, they can be found on the GoToWebinar navigation panel under the Handout section. Both the webinar recording and materials will be available on the BB&K website approximately 24 hours after the presentation. Thank you, and I will now turn the call over to our moderator, Mark Easter. Mark?
Good afternoon. Welcome to the final episode of our three-part webinar concerning dangerous and non-compliant buildings. In this 2-hour finale, and it will be a 2-hour session with a brief 3 to 5 minute break in the middle, we will be addressing civil remedies for dangerous buildings, focusing on the very powerful remedy of receivership. For this discussion, I am proud to say that we have assembled a very distinguished panel of some of the most experienced professionals in the areas of code enforcement and receivership in the entire state of California. First, Sam Emerson of Counsel in the Sacramento office of Best Krieger will provide us with an overview of the procedures in getting a receiver appointed. Sam has been heavily involved in receivership litigation since he first came to work for Best Krieger close to 15 years ago, and he has successfully litigated over 40 receivership actions throughout the state of California. Second, we have Andy Wingert, who is Code Enforcement Chief for San Bernardino County, and prior to that worked for 20 years with the City of Ontario. Andy may very well be both the biggest and longest running advocate of the remedy of code enforcement receivership in the entire state. I worked closely with Andy when we started up a very successful receivership program for the City of Ontario starting back in 1999. Andy will provide us with valuable insight on the benefits of a receivership program and how to implement such a program. Third, we have Greg Priamos, who since July of 2014 has been County Counsel for Riverside County. Greg is an active member and frequent contributor to the International Municipal Lawyers Association and the County Counsel Association of California. Prior to becoming County Counsel, Greg served as City Attorney for the City of Riverside dating back to the year 2001. As City Attorney, Greg was an active member of the City Attorney's Department of the League of California Cities, serving as President in the year 2013 to 2014. Greg probably rivals Andy as one of the greatest advocates in the state for the remedy of receivership. I've worked with Greg on many of these cases and have appreciated his enthusiasm and commitment to using these powerful strategies to save and restore communities while minimizing the cost to the public agency. Last but certainly not least, we have our experienced court-appointed receivers, Kevin Randolph and Nicholas Firetag of the law firm of Gresham Savage. I know that Kevin spent the first part of his career becoming one of the foremost experts in the state on redevelopment law. Kevin was also very instrumental in assisting and advising Andy and the City of Ontario when that city started up its successful receivership program. Kevin has since developed an expertise serving as a court-appointed receiver in these cases, having now been appointed as a receiver in over 70 health and safety code receiverships throughout the state. Nicholas has been with Gresham Savage since graduating from Pepperdine Law School in 2005. Nick has focused his practice on both business and real estate litigation and has been involved in receivership cases almost from the very beginning of his career. Both Kevin and Nick have excellent reputations as court-appointed receivers, and they will be sharing with us some of their more interesting and successful receivership cases, complete with pictures, which I am sure you are all dying to see. With that, and before I turn it over to Sam to get started, let me tee the discussion up with some context. We've been discussing in this webinar this idea that you should look at code enforcement as a toolbox with a variety of remedies, some administrative, some criminal, and some civil. The most common nuisances connected to properties include One second. There we go. Some of the most common nuisances connected with properties include unpermitted construction, grading without a permit, zoning violations, excessive trash, debris, and storage, state and local violations presenting housing and safety concerns, and drug houses and criminal activity nuisances. The civil remedies we will be discussing today are important for those more egregious cases where the problem has to be cured for public safety and welfare, but the property owner either lacks the will, knowledge, or resources to address it. Sam, why don't you begin by discussing how a city or county goes about gathering evidence to make its case. Then we can dive into the actual civil procedures and remedies.
Thanks, Mark. No matter which civil remedy we bring to bear, we'll need to gather evidence for that civil remedy. And in doing that, we'll have to be cognizant of the Fourth Amendment and its protections. I'm not going to go too in-depth in that because I think we've covered that in the previous presentation. But needless to say, when we gather evidence, we have to consider the rights and protections of the Fourth Amendment. The most common methods for gathering evidence for our civil action will be, first, observations from the public right-of-way. So anything that we can observe from the public right-of-way for our property, which is usually going to be the outside violations and violations we can see from the building, anything we observe is fair game there. That makes for good evidence, and we can use that. Second, we can get evidence by getting consent from the owner for an inspection. Now, a word of caution on consent. When we get written consent from the owner or the person who has the ability to give consent for the property, like a tenant, we need to make sure we get written consent for that as a best practice. It's better to get the written consent with some sort of just simple form that they can sign agreeing that they've given consent than to get down the road and face a fight in court about whether or not they've given consent. And believe me, it happens more than you think. If we can't get consent and we can't observe violations from the public right-of-way, then we'll need to go get an inspection warrant. So let's go to the next slide, and I'll talk about the requirements for getting an inspection warrant quickly. Here we go. So here are the requirements for the inspection warrant. The requirements and the procedure is set forth in the Code of Civil Procedure in 1822.51. And what it says is an inspection warrant may be issued upon cause supported by an affidavit, particularly describing the place, dwelling structure, or premises to be searched, and the purpose for which the search is made, and stating that consent to search has been sought and refused. Now, you might be asking yourself, what if I can't get consent from anyone to satisfy this particular requirement for an abatement warrant? That can be because we don't know where the owner is, or sometimes it can be because we're not entirely sure that the person who would give the consent has mental capacity to do that. Well, if we find ourselves in that situation, what we just need to do is let the court know the efforts we've made to get consent, how we've tried to find the owner, what steps we've taken to go ahead and satisfy that requirement, or explain to the court we're not sure that the person is mentally competent to give that consent, and so we haven't sought that from them. The real key is just to address that with the court and let them know up front. Let's go to the next slide and talk about what constitutes the good cause that's required under an inspection warrant. So good cause exists if, one, either reasonable legislative or administrative standards for conducting a routine or area inspection are satisfied with respect to the subject property, or two, there is reason to believe that a condition of nonconformity exists with respect to the property. So let's talk about one, the reasonable legislative or administrative standards for conducting a routine. What this is if there are state-mandated inspections that are required for this particular property, for example, a closely regulated commercial property or business, or sometimes there are requirements under the building code for that, or sometimes for permits that are inspections that are required. If those are required and the property owner won't cooperate with an inspection, that's good grounds for asking for an inspection warrant. But the more likely prong will be under number two. There is reason to believe that a condition of nonconformity exists with respect to the property. Now, how do we satisfy that requirement? Well, you only need a reasonable suspicion of that. So usually if there are violations on the outside of nonconformity, that will give rise to a reasonable belief that there are violations on the inside. Or perhaps we have someone who's complained who's seen violations on the inside. Putting that in the affidavit is usually enough to satisfy the court that there's a reasonable suspicion of violations on the inside. So once we've prepared the warrant and satisfy the requirements here in the Code of Civil Procedure, then what we'll do is submit that warrant to the court. Now, where do we submit it? You might be asking. Well, it really depends on the court. In some courts, it goes to the criminal court. Sometimes it's the presiding justice who decides on those warrants. But usually those warrants will be issued without the need of a hearing. However, sometimes the court will want to call in and ask the affidavit questions, and they're entitled to do that under the code. So it'll be a short hearing in chambers where the court will simply ask the affidavit any questions that they may have about what's written in the declarations. Once we have it and the court signs it, then we have to execute the warrant. So in executing the warrant, the question often comes up, well, what happens if we go there and we can't get into the property? Or what happens if we go there and the person refuses to comply with the warrant? Well, the Code of Civil Procedure has provided for that too. You can go and get what's called a forcible entry warrant. There are two criteria for getting that. First, you can show facts that are sufficient to create a reasonable suspicion of building or related code violations which pose an immediate threat to health and safety. So a good example of this is if you, for example, suppose you thought there was a gas leak in the property and the code enforcement officer had smelled gas on the outside and there's no one around to let you in. Well, you can go in and get a warrant that says we can break down the door and get in there because there's an immediate need. Now, I'll be candid, this doesn't come up a lot because normally if you have a situation like that, you're going to make use of the summary abatement procedures that we've talked about previously, but there is the option there for that. The next is you can establish facts which show that reasonable attempts have been made to serve a previous warrant and have been unsuccessful. So if you have a property owner who refuses to comply with the warrant, or every time you go to execute on the warrant, there's just no one to let you in, then you can go back into the court that issued the warrant, demonstrate those facts probably with a declaration, and the court will issue what's called a forcible entry warrant. That will give you the ability to open the door with reasonable methods to get in and do the inspection. So that's what we have on executing these warrants. If we go to the next slide, we'll talk about a few restrictions on the warrant itself. So here are some of the restrictions. The warrant will only be operative for up to 14 days unless extended or renewed by the judge. So that's how long you have, but if for some reason that's not good enough, then it's pretty easy to get an extension. And that's true even if the warrant has expired. Usually you just put in a declaration to the judge explaining the circumstances under which the 14 days was not sufficient to execute on the warrant. And sometimes that's internal. Sometimes you don't get the warrant back from the court until there's 4 days left to execute on that. I've had that happen before. Just simply going and asking for extension is usually no problem. The municipality must also post notice of the warrant inspection 24 hours before execution of the warrant, unless the judge waives this requirement. And sometimes there's good grounds for doing that. For example, I've had cases where the violation we believe that is occurring is an unlawful business inside a warehouse, or the person is living in there when they shouldn't be. And so what we've explained to the court is if I post 24 hours notice, then they're just going to remove everything that looks like they're living there, or remove everything that shows indicia of a business being run there, and then the inspection will be no good. So if you can justify it, the court will waive this for you, and you can go in and get your execute the warrant without the notice. Other requirements. The inspection may not be conducted between the hours of 6 p.m. and 8 a.m. of the succeeding day. Kind of makes sense. The court's not going to let you go in at strange hours to do the inspection. You have to do it between the hours that it's mandated by the code. And finally, the inspection must be conducted in the presence of the owners or occupants unless the requirement is waived by the judge. And I'll tell you candidly, I always put this in my orders that the owner and occupants have a right to be there, but it's not necessary that they be there. Just to avoid any hassles related to that. Okay, well now
Sam, now that we've kind of talked about how we're gathering the evidence, how we've gathered the evidence, let's get into what the various remedies are to choose from, and why don't we start with the abatement warrant remedy?
Sure. Thanks, Mark. So there are various tools, and one of the tools for abating a nuisance is an abatement warrant. So let's go to the next slide so we can talk about abatement warrants. So An abatement warrant is a tool that we can use usually for minor nuisances. And again, in doing that, we have to be cognizant of the Fourth Amendment. It gives people the right to be secure in their persons and property. So what this means is that the code enforcement officers may not enter private property where there is an expectation of privacy without consent or some sort of court order to abate the nuisance. So given that constraint, how do we accomplish that? We go get what's called an abatement warrant. So go to the next slide, Mark. Now, I'll be candid with you. Unlike an inspection warrant, which is provided for under the code, there's no real statutory authority for an abatement warrant. The closest thing we have is what I'm showing you here on the screen, which is the case of Hyde versus the City of Dana Point. And in this case, the city went and got an inspection warrant, but at the same time, they also asked the court for the ability to abate certain nuisances on the property pursuant to that warrant. And then that was challenged in court, and the court decided that that warrant passed statutory muster, and here's what it said. It said it passed constitutional muster because it mirrored the statutory requirements for other types of warrants. For example, the warrant was issued pursuant to probable cause to believe grounds for abatement existed. It was shown by an affidavit which also particularly described the place to be inspected. The warrant was in writing. It was directed to state and local officials and commanded the abatement authorized by an appropriate law. It also particularly described the place where abatement was to take place and designated the purpose for the intrusion and the limitations on it. So this particular part of the case is in a comment section, so it's really arguably dicta, but we've used it to get every abatement warrant gone, and the court is satisfied that the grounds exist for that as long as you can show that the requirements that are normal for warrants have been met. So let's take a look at those requirements. Just like for an inspection warrant, which we'll use sort of as our model for getting an abatement warrant, you would need an affidavit, and it would have to describe the place, dwelling, or structure where abatement will occur and the type of work that will be performed. The court's going to want to know that. You have to state that consent to do the abatement work has been sought and refused. You have a property owner that refuses to do the abatement. And you have to demonstrate cause for requesting the abatement warrant. So let's go to the next slide and talk about what cause is going to look like for an abatement warrant. To demonstrate cause here, we're going to have to show concretely that and prove to the court there are violations of state or local law on the subject property, which must be remedied, and that the owner has failed or refused to remedy the violation. So you're going to do this with declarations from your code enforcement officers and pictures describing the violations, showing the court that they exist and they need to be abated, and the property owner won't do that. Again, you'll submit it just like you would an inspection warrant into the court, and they'll usually sign off on the abatement warrant without the need of a hearing, but if they require one, then you'll just bring in your declarant, and the court can ask what questions it needs to satisfy that it needs to be issued. And once you have that warrant, then you have your court order, which allows you to go on and take care of that. So let's look at the advantages.
Sam, why don't you go ahead and share with us Why don't you guys share with us the advantages and disadvantages of the abatement warrant?
Sure. Let's look at the advantages. So the first advantage is it's the quickest solution. It's obviously, when we're talking about other civil remedies, you need to, when you're filing an action, it can take a while, whereas the abatement warrant is pretty quick. You can usually get them issued within 24 to 48 hours. And depending on how quickly the jurisdiction processes the warrant, and so you can get right onto the property. It gives the municipality the ability to perform the work so that it can be done correctly, and it gives us you can sometimes recover the costs associated with abatement as a lien against the property. There are disadvantages, however. Let's go to the next slide and take a look at those. Go ahead and go to the next slide and talk about the abatement disadvantages. So the disadvantages are it's really not a good remedy for large-scale nuisances. And the reason for that is that the city has to front the costs of rehabilitation. And if we're talking about a large-scale nuisance, this can be quite expensive. For example, like demoing a property. Not probably a good idea for an abatement warrant because that's going to involve large-scale expense. And really, the municipality may never recover the cost of rehabilitation, or they have to wait a long time to do that because we're talking about a lien that has no preference here. So whatever else is on the property in terms of trust deeds, judgments, and usually these properties have those, you're going to have to wait according to your order of preference, and you're going to have to wait until either the property is sold or it's foreclosed on or you have a refinance or something.
Sam, before we go on, we did get a question. When you were talking about the 24-hour notice a few moments ago, the question is that based on statute or case law, and what are some examples of situations where courts have waived the 24-hour notice rule?
Sure, that's a good question. So the requirement is straight from the statute, so it's a statutory requirement. And one example is the example I gave, where you think that the evidence is hideable. In other words, where you think there's reason to believe that they may be able to cover over let's take non-conforming work, for example. If you have previous evidence to suggest that they drywall over that every time you come to look at that, or if you have sort of can make an argument that they will be able to hide the evidence, like, for example, using a warehouse as a residence or running an illegal business out of that. If you think there's an argument to be made that they can hide that before the inspection if they're given notice, then you can usually make an argument to the court that they should waive that requirement, and I've successfully done that many times.
Okay, so let's get into the remedy we're all really interested in, and that's the remedy of the Health and Safety Code receivership, Sam.
Great. Let's go to the next slide. So let's talk about when to use the tool here. This is the optimal tool, really, for residential properties where the buildings have extensive state and local law violations which endanger health and safety. And it can also be used for commercial properties where the buildings, which are used for, you can be argued that the buildings on the commercial property are used for human habitation, and where the buildings have extensive state and local law violations which endanger health and safety care. If you can meet those requirements, by far, the health and safety receivership tool is the best tool for combating your nuisance property. And we're going to explain why in the next few slides here. Let's go to the next one, Mark. So first, let's talk about what a receiver is under the Health and Safety Code, or what a receiver is in general. The receiver is the court's agent for enforcing its orders or maintaining the status quo. You may be familiar with the use of receivers in things like foreclosure and bankruptcy and business dissolutions, where the receiver is charged with keeping and running the property while those different processes take place. Under the Health and Safety Code, under Section 17890.7, the receiver's job is to take action to correct the conditions cited in the notice of violation issued by a municipality. So let's go to the next slide, Mike. Those responsibilities can include taking control of the property, managing the property, collecting rent or paying expenses from the property if that's needed, obtaining repair and rehabilitation estimates for repairs to the property pursuant to the notice issued, borrowing money and entering into contracts that allow for that rehabilitation work to happen, and relocating tenants if there are tenants on the property that need to be relocated while the work is done. These are just some examples of the powers receivers have under the Health and Safety Code. It's by no means an exhaustive list. Let's now look at the procedures for obtaining a receiver under the Health and Safety Code. It all starts with a complete and thorough notice and order to the property owner and to all interested parties, which is then served and posted on the property and describes the violations that are on the property and what needs to be done to correct them. And then the property owner has to be given a reasonable opportunity to make those corrections. If the property owner doesn't do that, then a 3-day notice of the municipality's intent to file a petition to have a receiver appointed must be served. And the violations here must substantially endanger the public. They must be very serious violations. We're not talking about just weeds or a little graffiti or sort of minor violations of that ilk. We're talking about things of different nature here, and we'll discuss more about what that means as the presentation goes forward. We then file a petition to have the receiver appointed, and then have that receiver appointed either by notice motion or by ex parte application. So let's talk about the first part of the first procedure here in more depth, the notice and order in our next slide.
Sam, before we do that,
Yes.
Kevin and Nick, could you kind of talk about some of the due diligence that you will undergo in determining whether a property is a receivership candidate from an economic perspective or from just a public use perspective?
Sure, Mark. This is Kevin. Nick and I make a pretty good team on these cases. He handles the litigation side of these matters, and I handle the transactional. And as such, I'm the one that gets to do the economic analysis. I mean, at the end of the day, one of the beauties of the Health and Safety Code receivership is that you can make an improvement to the community and the cost isn't borne by the public agency. It's actually borne by the property owners, and in some cases the lenders on the property. And I'll explain that comment in a second. For any receivership case to be successful, you have to have at least an economically feasible project. And the only way that we've found to be able to predict that is to basically go boots on the ground. And we oftentimes ask that when code enforcement goes out for the first time on a case, or excuse me, the last time on a case before they file, and if they're considering a receivership, we ask them to include us both on the inspection warrant, so we have some protection, as well as let us accompany that. We come out with our property and construction management folks, and we walk the property. We see what we get a good look at the inside, we get a good look at the outside, and usually working with city staff, city code, city building officials, we'll come up with two rough estimates. One is a rough estimate of what we think the rehab cost would be. And although it's not an exact science, after a number of cases you get pretty good at that, and I think we have. And the other guesstimate you come up with is what you think the value of the property would be following its rehabilitation. Although a property owner and even a lender on a property has the right to redeem the property prior to the receiver's sale of it, that rarely happens, and we usually expect that we're going to end up selling the property. So what we're doing is looking to make sure that there'll be sufficient funds to cover a number of expenses. Those include the rehab costs, those include the receiver's fees and expenses, operating expenses, the city's attorney's fees and enforcement costs, and in those cases where it applies, administrative fines and penalties. So it is very simple math, and you look at the end, you take all those numbers, starting with the value, the expected post-rehab value, and subtract out all the expenses, and we take a look to see whether or not there's sufficient funds to make that property a viable candidate. And it's surprising, and for a reason I'll explain in a second, most of these homes are. The reason they are is that one of the things that, at least in our receivership cases, the position we take and have been successful so far in promoting, is that the receiver's money, the money that the receiver borrows through receiver's certificates, enjoys a super priority lien over any existing other liens other than state and local or federal taxes. But we get the ability to leapfrog in front of existing mortgage holders, existing other lien holders. Now, you won't find that particular fact stated in the Health and Safety Code. However, there is case law to support it, some very old case law and some more recent case law, which does support the fact that a court, although it's not automatic, a receiver's super priority, a court has the equitable powers to put the receiver's certificate in front of existing lien holders. And knock on wood, so far we've been able to, we've been successful in convincing the courts that they should do so. So that's just a little bit of the background. We do economic analysis, and that often determines the type of rehab we do or the type of receivership approach we take.
Okay, thanks, Kevin. So, Sam, why don't you go ahead and talk about the notice required to set up a receivership action?
Great. So, under the Health and Safety Code, under Section 1790.6, it provides that if any building is maintained in any manner that violates any provision of this part, meaning the Health and Safety Code, the building standards published in the State Building Standards Code relating to the provisions of this part, any other rule or regulation adopted pursuant to the provisions of this part, or, and this is key here for most municipalities, or any provision in a local ordinance that is similar to a provision in this part, and the violations are so extensive and of such a nature that the health and safety of residents or the public is substantially endangered, the enforcement agency may issue an order or notice to repair or abate pursuant to this part. So this is what kicks off the receivership action. The authority under this particular section to issue a notice if it violates basically any state or local housing laws. Let's talk about what has to go in this notice under the 17980.6. First, we need a complete and detailed description of the violations. We'll also need the name. The Health and Safety Code requires the name, address, and telephone number of the agency that issued the notice or order, the date and time and location of any public hearing or proceeding concerning the notice or right to request a hearing if a hearing will take place. And it also requires information that the lessor cannot retaliate against the lessee. Let's go ahead and look at the next slide, which will talk about service and posting. There's some requirements in the Health and Safety Code for that. It provides that the order shall be provided either by posting a copy of the order or notice in a conspicuous place on the property and by first-class mail to each affected residential unit. If it's a single-family residence, that will be one. Or by posting a copy of the order or notice in a conspicuous place on the property and in a prominent place on each affected residential unit, and that's imagining sort of an apartment complex. Now, if there are requirements in your municipal code for service of a notice, you'll need to comply with those two to be safe. Usually that requires sending a certified mail to all parties on the packet or title.
Okay. The problems with a poorly drafted notice and order that can come up.
Yeah, ideally the notice, it should be entitled a notice and order. It should be sourced ideally in a building code or a related code, because building codes they're really not subject to discussion. They're laws that have to be obeyed. You really do need to list all of the violations you want to see abated, because if you have to go to court, the court really only has the authority to ensure that that which has been noticed can be abated or repaired. It has to be a legally complete notice administratively. In other words, if you want to have a completely exhaustive administrative remedy when you hand this off to your attorneys, you don't want to be going back and re-noticing and double clutching. And it should make it clear what the outcomes are if somebody fails to obey the directives of the notice and order. You probably need to state there'll be some kind of prosecution, civil or criminal. You need to state demolition's a possibility, if that's a possibility, and or a receivership petition being filed, so that the responsible owners or property owners cannot claim that to the court they did not know what the outcomes were, because receivership is perceived as a harsh remedy by the court. And I have seen receivership matters that where this type of code we didn't use building codes to source the notice and order in. It was sourced in a land use matter, and literally the case drug on for 20 years. So that's why you want concise notices sourced in bodies of law of really great dignity, if all possible.
Okay, Sam, so why don't you share with us what happens procedurally if the property owner gets a notice like this and fails to comply?
Great. So if they fail to comply, then we move into our next statutory authority, which is Health and Safety Code Section 17980.7. And that provides that if the owner fails to comply within a reasonable time with the terms of the notice and order issued pursuant to 17980.6, the enforcement agency, tenant, or tenant association or organization may seek, and the court may order, the appointment of a receiver for the substandard building pursuant to this subdivision. In its petition to the court, the enforcement agency, tenant, or tenant association or organization shall include proof that notice the petition was served not less than 3 days prior to filing the petition pursuant to Article 3 of Chapter 4 of Title 5 of Part 2 of the Code of Civil Procedure, which I'll tell you now requires that notice be served in the same manner as a legal complaint is served. So usually means by personal service, substitute service, or another means provided in the Code of Civil Procedure. And it has to be served in all persons with a recorded interest in the real property upon which the substandard building exists. So let's talk about the service of those 3-day notices. How do we find those parties? Well, it's not difficult. They usually can be found by, since it's a recorded interest, you can find it with a preliminary title report or a litigation guarantee. And I would recommend strongly the latter because that will give you some sort of title insurance to guarantee title on the property. So, for example, and usually for about $500, you can get about $50,000 worth of coverage for what they hold out as for what the recorded interests are on the property. And so you'll look down that and you'll find all the people who have trust deeds and judgments and other types of liens on the property. And you'll need to give a 3-day notice to all of them. So the next question is, well, what happens if I can't find someone with a recorded interest in the property? Well, unfortunately, the Health and Safety Code really doesn't answer that question. So we've developed approaches for that. If you can't find a lien holder and you have to serve them with a 3-day notice, what we've done, what I used to do, I'll tell you candidly, is I used to serve everyone I could with a 3-day notice, and then I'd go into court and just ask to publish the petition and the notice of motion. I did that until one court told me that approach was not going to be good enough for its jurisdiction and said that the requirement for a 3-day notice was absolutely jurisdictional. In other words, you couldn't even proceed with the petition until you did that. And so now what I do, if I can't find the owners, I go ahead and publish the 3-day notice in the paper like I would a petition, as if I had a court order allowing me to publish a complaint or a petition. And that usually satisfies the court. In fact, almost always it has. So that is the approach now that you have to take if you cannot find a person with a recorded interest that you have to serve a 3-day notice with. So let's talk about what is a reasonable opportunity to correct, which is one of the requirements before you can bring a Health and Safety Code petition for a receiver. So what's a reasonable opportunity? 30 days reasonable, start, 60 days to complete? Well, it really depends on the violations. You want to give them a reasonable time. In other words, you want to give them sufficient time to at least get well started on taking care of these violations. Maybe not completely complete them, but you want to give them at least a reasonable amount of time to get most of them done. I usually give them 30 days. The courts usually decide that 30 days is presumptively reasonable. So that's how much time you want to give in your notice, at the very least, is 30 days. Our next requirement is that the violations that we're talking about have to be substantially endanger the public. So the violations must be extensive and of such a nature that the health and safety of residents or the public is substantially endangered. What kind of violations are these going to be? Well, they're going to be fire violations. The courts will really take notice of fire violations, especially now, as we've emerged from drought. If there are structural violations on the property, those are going to be deemed health and safety problems. So your listing buildings, your roofs caving in, crumbling foundations, those are going to be good enough. Mold usually gets the court's attention, particularly if it's black mold. If the property is infested with vermin that causes concerns for disease, the court will take notice of that. That's probably going to be enough. You can also have properties that have a large accumulation of lesser violations. So if the property is simply riddled with all kinds of violations, even though any one of them isn't necessarily very serious, the cumulative amount of them is, then the court, that will usually be enough for the court. If you can make an argument that the property is an attractive nuisance, in other words, if it's open, if children can get in or vagrants, and there's a possibility of them starting a fire, if there's evidence that they've been cooking in there, things of that nature, or there are things in there that would be dangerous to children or vagrants who might go in, that's probably going to be enough to make the argument that a substantial danger exists to the public. Let's go to the next slide. So what about a vacant property? Can that really be said to be dangerous to the public? Well, the court has answered that question for us in the case of City and County of San Francisco, where they said that the residents mentioned under Section 17980.7 include not only anyone who's in the property, but those who live nearby the property too. So we can now make that argument as well.
So Sam, you have some illustrations of substantially dangerous properties, and I'm sure that Greg and Kevin and Andy and Nick also have some thoughts on this, but you have some illustrations that we're going to go through then?
Yeah, let's take a look at some cases I've done here. We'll demonstrate what we mean when we say substantially endangered. So it'll be violations like this. Here you can see some exposed wall joists, exposed wiring. Even what's around it is not looking very good here. This kind of thing will definitely qualify as substantially endangering the public. If you go to the next one, here we see evidence of water damage, rot on the walls, that kind of thing. Looks like there's some mold coming in there. Again, this type of violation, you can see in the ceiling there's water damage and evidence of water intrusion. This is going to work for substantially endangering the public, serious violations. If we go to the next one, I'll show you a particular property I just worked on. This one I like to call the rat house. At the time that the code enforcement officers went to inspect this property, the property was so full of rats that they were falling out of the trees. And that is not even an exaggeration. They were actually falling out of the trees. They were coming out of the trash cans. When the code enforcement officer went to knock on the door, no one answered, but a rat actually pressed itself up against the window and eyeballed the code enforcement officer. This place was a mess. It was so bad that the code enforcement officers, when they did the inspection, had to don hazmat suits because of the rat feces and mold in the house. And you can see, I've given you the before and after so you can see that we had a happy ending for this case, but you can see the mold on this particular picture, the before picture along with the structural damage there. If you want to go to the next slide. This was the outside of the property beforehand. That car had the property owner's sort of vagrant son living in it, so we had that problem as well. You can see the overgrowth there. And then in the after picture, you can see that it was vastly improved on the outside, along with cutting down the vegetation, the fence is nicer, all that good stuff. If you go to the next slide. As you can see, the kitchen looked like a mess here. Mold, rat feces, garbage. It's been stripped of anything of value. I mean, except for maybe a dishwasher there. I don't know what kind of shape that was, and we replaced that anyway. If you look at the after picture, you can see what the receiver was able to do with the equity that was in the property. I think we can agree it's a vast improvement. Sorry to show the next one at lunchtime, but this is, if you go to the next one, this was the toilet area, absolutely horrid evidence of vagrancy, and it's nothing you would want. If you look at the after picture, you can see that we were able to fix that up. So these are the kind of violations we're talking about. This may even be on the extreme side. I don't know if you need to even get this close, but just to give you an example of what we mean here.
Yeah, Sam, before we go on, I'd like to just ask this of the group. And one of the things I found is that the circumstances which lead to this are often varied. Could you guys give us some examples of what leads? It's not just that the neighborhood's bad or the economy's bad. Can you guys share some examples of sort of unique circumstances that lead to properties falling into this condition?
Yeah, I mean, I think a lot of times we see mental health issues. We'll see that some event will happen in someone's life. You'll hear about a divorce or maybe a former military person, and they simply lack the capacity to be able to take care of their property. Death in the family tends to be a very common one, where someone will die, the property had already fallen into disrepair, and the beneficiaries of the home choose not to open a probate, and no one takes over ownership. And so it'll sit there for, it could be a couple of months, it could be 10 years, and it'll sit there, and death seems to be probably one of the more common ways. And then you'll start to get vagrants and people breaking into homes. So if they are left abandoned, you start to have that, and they become their pseudo homes. And we've even seen situations where people that are squatters will actually turn on city services, and they'll live in it as their own home as long as the services are provided.
In the City of Riverside, we also had instances where the banks would foreclose, but they would never take physical control or custody of the property. And then you would see all of the attractive nuisance activity that would be attracted, obviously, to such a property. We've also had people who purchased the property and never moved in. and they simply left it. And then, of course, if it wasn't in a substandard condition at the time they acquired it, it soon becomes or is carried into that condition.
Yeah, and I think it's important that it's not just the bad neighborhoods. I've seen them where, like, even in vacation counties like Santa Barbara County or Ventura County, the family there's a vacation home, and then the parents die, and the kids live on the East Coast, and they have no sense of what's out there and don't want to bother with the probate, and there it sits, and then you have these problems.
I mean, Kevin and Nick and I in the City of Riverside worked on over 50 receiverships, and they were not limited to any one particular neighborhood of the city. And we had properties that were worth well in excess of $1 million, and we had properties that we struggled to find economic value at $50,000. It was the entire spectrum.
And Andy, I think that was true in Ontario.
It was, and I think what's really why this is such a wonderful remedy is that this can stabilize a neighborhood. We had a house that, where the owner of record was deceased. Her granddaughter was a drug addict and was living in it without utilities with her friends, and it was a very solid middle-class neighborhood. And they called upon the city to address it, and the city addressed it, and their comment was, "Thank you for saving the neighborhood," because it really did do that, stabilized everything.
Okay, so Sam, why don't you go ahead and talk about, let's move to the next slide, let's talk about the actual appointment of the receiver, how it works by motion in court.
Sure. So assuming we've cleared all the procedural pre-filing requirements for receivership and we have the violations we need to demonstrate that, your next step, after you serve the 3-day notice and 3 days have elapsed, you file your petition. Now, what is the petition? It's going to look a lot like a legal complaint, and you're going to have to lay out the parties and lay out the legal grounds for having the receiver appointed, set forth the violations, demonstrate the history of noncompliance here, and you're going to have to also demonstrate to the court, at least at the allegation level, that you've satisfied all the requirements for receivership ahead of time. Once you file a petition, you're cleared to then file either a notice motion or an ex parte application to have the receiver appointed. And I'll tell you, ex parte receiver appointment, while possible, is rare. And that's because by now, usually by the time you go into court to get this, you've been dealing with these violations for quite a bit of time. And though they're serious, the dangers you're sort of articulating are, if we don't do something about this, X could happen. And so because ex parte, you need a little bit of urgency. To get an ex parte appointment or receiver, you're probably going to have to show some new circumstances. So as an example, I had a receiver appointed ex parte successfully once, and that was where, right before as we were filing the petition to have the receiver appointed, there was some bad weather and some wind, and the building actually started to lift and looked like it was going to tumble over. So in that case, we felt like we'd go into court and say, look, this is a changed circumstance, and it's imminent here. And the court agreed with this. So the court went ahead and appointed the receiver by ex parte motion. And what that is for maybe any non-lawyers listening is that you can do that sort of almost within 24 hours, get a receiver appointed. But most of them are going to be done by notice motion, and you'll need to file a motion with the normal parts you would put in a motion and put in your evidence. The evidence is going to be declarations from code enforcement officers, building inspectors, fire inspectors. If you can get neighbor declarations, the court loves those because it shows how the community is affected. Really, a declaration from anyone who can demonstrate to the court that they're affected will be good, and the court will like to see. For example, I had a school principal give us one once because the property was affecting or causing a danger to kids who were walking by. They had some kids caught in the house. The principal found out about it, was concerned, and gave us a declaration saying that the receiver should be appointed. That helps out. You'll want photographs, obviously, of the violations, so you can prove to the court they exist, and so the court can see the severity. Really, the pictures oftentimes tell the whole story. If you can get some good pictures in there of the violations and put them in front of the court, it speaks volumes, really more than anything else you might write or say to the court. And then you want to put in a proposed order, and there's some considerations you want to have for that order when you put it in. And maybe our receivers can talk about that.
So Nick and Kevin, I asked you to talk not only about what you like to see in the order appointing the receiver, but also just why don't you take us through the steps that you take once you are appointed a receiver.
Okay, and I can do that. This is Nick. We actually, Kevin and I, we've been developing our receivership order really for the past 9 or 10 years. It's something that's developed over time because there is case law from the 2005 California Supreme Court case that talked about a receiver's duties and where our powers come from. It comes from a statute, the order appointing receiver, and future orders of the court. And while the Health and Safety Code 17980.7 is detailed, it leaves out a lot of issues that we have come across over the years that we realize that we need. We need specific injunctions that will prohibit the property owners from coming back on the property or interfering. We want to be able to prohibit secured lenders from foreclosing on their liens because that can impact us on title. We want to have the ability to hire a locksmith to come in and lock up the property. We want to have the ability to hire real estate agents to sell it. And so having a receivership order that covers all of these powers is important. Otherwise, as a receiver, I have to go back into court and file a motion for instructions every time I want to do something outside of that order. And so our order has been crafted in such a way that it covers everything that we need without having to go back into court. Now, once we're appointed, our first step is to take over possession of the property. I'd say well over half the times, these are vacant properties, and so taking possession just requires us to have a locksmith come out. But if there are people living there, then each situation is unique, and we have to deal with them as they're there. If it's the property owner who caused the harm, we have an order that they leave the property immediately, and if they don't, we can have them evicted. We already have the order giving us possession, so we just contact the sheriff and have them evicted like a normal unlawful detainer. If it's a tenant, though, and the tenant did not cause the problem, the Health and Safety Code allows us as receiver to provide them with relocation expenses and to move them from the property. We will do that every time it's possible, that we will borrow funds ahead of time to move tenants, especially innocent tenants, to another place. And then for those tenants who don't leave, we have to remove them just the same. And so the same order that gives us full possession of the property, we use that to remove any tenants that hold over. We very, very rarely do we actually have to have the sheriff come out and remove people. We go out personally, we meet with the people who are there, and we negotiate it ahead of time. And we've been able to do that very successfully. Once we have control of the property, our next step is to prepare a rehabilitation plan. What is it going to take to fix up the property? And that plan, it will either be done by us and our contractors, or if the property doesn't have a lot of value in it, we might look into bringing in an investor buyer to come and do the work under our supervision. And so once we have our plan, we go into court and we get approval for the plan. We find that courts will allow us to do it on an ex parte application, so we can go in quickly to deal with the issues. But we want that court approval. We want the court to see exactly what we're going to do, how much we're going to borrow, who's going to get paid, where those funds are going to be used. If it's an as-is sale, we want the court to approve that sale because not only do we want to make sure all the parties have notice, but we ultimately have to deal with the title insurance carrier that's either going to provide a lender's policy for our lender to borrow funds or a title insurance policy to our new investor buyer. And so we need to make sure that everybody has notice and that the court has blessed it. Once the court approves the plan, whichever of those two it is, I guess a third option would be we can demolish the property. We use that rarely on single-family homes, but on commercial property, we find that sometimes that's the best value. It's just to sell it as a dirt lot. But once we have court approval, we borrow the funds, we complete the rehabilitation work, and then when we are finished, we then file, if it's our rehab and we've done the work and no one's willing to pay off the costs, then we will ask the court for permission to sell the property to a specific buyer. We'll have already listed it and found a buyer, and we'll get court approval to sell it and then ask for the distribution of funds from there. And the distribution of funds is important to know where that money is going to go, because often on these properties we have secured lenders and there's not enough money to pay everybody on most of these properties, we find. And so that distribution of funds is very important to us. The order of priority that we've come up with that seems to make the most sense is we have to pay off our contractors first who did the work. They want to be paid in full. Next, we look at the receiver and the city to try to pay off our fees and costs and the city's fees and costs. And then from there, we'll start paying secured lenders based on their order of priority and ending up with the homeowner. receiving whatever is left over. And there are occasions where we'll have sometimes substantial funds left over for the homeowner. And so once we're done, we'll get an order for discharge, and that's the end of it.
We're going to do right now is take about a 3-minute break, and then when we come back, we're going to discuss a few more procedural issues, and then Kevin and Nick and Greg are going to show us some great examples of their use of the receivership, and then we'll discuss a few other remedies and finish up our time together with a great roundtable discussion on the receivership remedy. So check back with us in about 3 minutes. Thank you. And cost recovery for agencies bringing health and safety code receivership actions.
Great. And this is really the best part about the health and safety code receivership is that there's the ability to recover attorney's fees and costs and pay for all of that through various means in the receivership. So the health and safety code has a statute which allows for attorney fee recovery. It's contained in 17980.7 subdivision C11. And it says the prevailing party in an action pursuant to this section shall be entitled to reasonable attorney's fees and costs and court costs as may be fixed by the court. So prevailing party in this sense will be the party if you successfully have the receiver appointed. So if you've had the receiver appointed, you're going to be the prevailing party. And then it's just a question of having the court decide your fees are reasonable and awarding them to you. So since the court has to review them, you're going to have to bring a notice motion for those fees and present it to the court and have them approved. So usually that will be done at the end of the receivership so that you can capture all the fees that have been incurred, not only in having the receiver appointed, but in monitoring the receivership as it goes along. Priority of fees is important, and as our good receivers mentioned, Nick and Kevin, we get that priority by case law. There's nothing in the health and safety code that mentions that. The courts are very receptive to providing priority for those fees above all the other liens on the property, usually except tax liens, both federal and state. So getting an award for attorney fees is one thing, but actually recovering those fees is something else, and that's where the receivership remedy again is ideal. So how are those fees and costs, both for the receiver and for the city, as well as the rehab costs, recovered? Well, as the receivers mentioned, they're recovered by virtue, usually in two ways. First, the owner can pay for them, and as strange as it sounds, it has happened to me a few times. I've had a couple times where the property increased so much in value, the owner came and said, "I'll pay off all the costs." And they've done that in cash sometimes. I had one property owner who just came to me and asked me if I'd take his personal check, which made me wonder if he had the funds to do that, why he hadn't repaired it in the first place. But at the end of this May, he went and got certified funds and paid it off. Sometimes they can refinance. I've had a couple receiverships resolved by the property owner getting a reverse mortgage that covered the costs of the property. So those are ways the owner can settle it sometimes, but more often than not, the property will be sold by court order to pay for everything, which has two advantages. I mean, first, you get the money reimbursed, and then second, it's usually sold to someone who's a responsible property owner, so you don't have this property sliding back into health and safety code violation land. So we usually get a responsible property owner in there too. That's another benefit.
Greg or Kevin, could you comment on that, how you've seen typically the agency recover their costs at the end of the receivership?
Well, just to amplify on what Sam said, we had one case in which the receiver was appointed, and the bank which had foreclosed finally became interested and then stepped forward. But we were not convinced that they were going to complete the rehab in a timely manner. So ultimately what we agreed to was that the receiver would remain in control, but that the bank could hire the contractors, could pay the contractors directly, and the receiver would supervise all of the work and its progress in order to ensure that the bank, number one, could rehab it at a lower cost than presumably what the receiver could. They could maximize what would be the remainder once the property was rehabilitated, minimize the cost of the receiver, and then sell it so that they would have something left after they paid the receiver and they paid for our attorney's fees and costs.
The other comment I would make is that I know that one question would be, do you have to actually get the receiver appointed, and does the receiver have to finish the job to get the attorney's fees? And I believe the answer is no. I've had several cases where, for whatever reason, the court itself chose to essentially act as the receiver. And we had the Gene Hart case, Greg, where we had all these properties, and Judge Fields didn't want to turn it over to a receiver, so he basically kept bringing the parties back every month for progress reports. And Judge Riley and Bernardino, same thing on a homeowners association, but didn't want to, instead of appointing a receiver, chose to basically, they may not realize that they were doing this, they're basically making themselves the receiver because they're bringing the parties back every month for progress reports. So, but my point is, if the rehabilitation is successful through that court supervised process, the court should still award whatever attorney's fees that have been incurred by the agency to get to that point.
But in most cases, in the over 50 receivership cases that we filed in Riverside, in the vast majority, the city's costs and fees were reimbursed. But there were instances, though, where we had the property also incurred administrative fines and penalties. And so in a number of these cases, what we did is we waived those administrative fines and penalties in exchange for an owner occupancy covenant. The law is clear that a city or county may impose through negotiations an owner occupancy covenant, and if city or county money is used as consideration for the covenant, that they have a right to enforce the covenant in court if the covenant is violated. And so we use that very effectively to gain owner occupancy, and people who would live there, that they would raise their family there, they would become part of the neighborhood, part of the community, and that it would not become a rental, or the property would not simply just get flipped from one investor buyer to the next investor buyer. And that was our long-term solution to trying to reduce calls for service to code enforcement, to the police department, et cetera. And so that was a very effective tool, and to the extent that the city or the county is willing to provide consideration for an owner occupancy covenant at the end of the receivership process, I would strongly recommend it.
You know, Mark, can I just add something also about?
Yes, Kevin, go ahead.
Sorry. Just simply in terms of economic recovery for the city, I mean, there certainly is the direct recovery, attorney's fees, administrative fines, and penalties. But another thing that we keep track of is the increase in property values in the neighborhood. We oftentimes we'll go into a property and on a per square foot value basis, when we get done with it, it turns out to be one of the highest valued properties in that neighborhood. And as a result, it brings up the other property values, simply, you know, the way real estate values work. And the city recognizes indirectly, and I don't know how it would be quantified, but it's still some amount, additional revenues just from the increased property values that rehabbing a single home or two in a neighborhood can bring.
Well, they just become comparable sales or comparable rents that enter into the stream of information.
Exactly right.
So, Sam, why don't you share with us some other uses, various uses of the receivership remedy, and then I'm going to hand it over to Kevin and Nick and Greg to go through some of their, I guess we could call them war stories or interesting property stories with the accompanying pictures.
Sure. So many times, a vast majority of the receiverships are done on single-family residents, but there are other places where it could be used too. As I mentioned before in the beginning, if you can make an argument that the property has a human habitation component to it, even if it's a commercial property, then you could probably do a receivership. So hotels and motels, probably, yeah, you can do a health and safety receivership under 17980.7. Common interest development, sure. Multifamily residential, so apartment complexes, duplexes, things like that, sure. Those will probably be good. I've done many on multifamily residential units. But how about our friend the mobile home park? Unfortunately, not on this one. Unfortunately, even though people live in those, and you would think that would be a good candidate here, the actual mobile coach is not considered a building under the code. It's actually considered personal property. So there is a way to get a receivership over a mobile home park, but it won't be under the health and safety remedy. You'll have to use another one under the Business and Professions Code. We'll talk about that a little bit later in the presentation.
Before we go to the pictures, there were a couple questions I wanted to address. The one was, and this would be for Kevin and Nick, and that is, do you have any sample rehabilitation plans?
You know, a rehabilitation plan is particular to each and every property. But I'll give you some, it really looks like a scope of work. If you were going to hire a contractor to repair your home, you'd see something very similar. What we do is we have on our staff property and construction folks that will prepare, will take the notice and order that the public agency has prepared, and using the code references, we'll create a list of corrections that specifically addresses each code violation, and then we're going to send that out to bid. But again, there's really no typical rehab plan because it just depends on the circumstances and the particular violations of each home. But one thing you should have, of course, is a clear connection between the repair being bid and the particular code violation being addressed.
The other question we had, which I will make an attempt to answer, is how much involvement would a code enforcement officer have in obtaining a receiver? Would it be done by the city attorney? And I'd like Andy's input on this as well. The code enforcement officer's role is very important at the outset in terms of making sure the inspection is done correctly and that all the violations are identified and that the notice is prepared correctly and identifies all the violations and is served correctly. Because if that isn't done correctly and the file isn't prepared in an organized way, is thorough, it makes the job for the attorney, whether that's the city attorney or outside special counsel, it makes their job very difficult to go into court and get a receiver. So it really is, it definitely is a team effort. If the code enforcement officer has done his or her job in terms of the inspection and identifying the violations, it just makes the attorney's job going into court that much better. I know, Andy, you have some thoughts on that.
I think we collectively learned early on that it was a good idea to have our receivers be attorneys because not all receivers are attorneys, and the bench will be uneven in terms of the respect they will accord a non-attorney receiver, whereas a receiver who is an attorney is completely free to address the bench. So I think we learned that early on. The other thing is that I think code enforcement, experienced code enforcement officers have a real good sense of sort of the credibility of what's going on once the rehab starts. Early on in Ontario, we had some rehabs that were being done that did not meet my standards, meaning, you know, and the scope of work didn't match up with what actually occurred. I mean, it was nothing super serious. I mean, it was okay at the end of the day, but I know we talked about it, Mark, when that happened, and that also led to there being more input on collectively. So it's a partnership between the code enforcement officer and the city attorney's office, I think.
That's true. Kevin or Nick, could you answer this question we just had, which is, and I trust this has to do with the rehabilitation work, that is, do you have to pay, include prevailing wage?
No, we're not a public agency. We're not receiving public funds. Court-appointed receiver just means we've been appointed to take over property to do something, but we borrow private money. We don't borrow it from the city or anybody else. So no, we never pay prevailing wages.
And that's worth a mention too. Is one thing that the receiver is not. This receiver doesn't represent either the city or the property owner. We truly are a court neutral. We're not paid by the city. We don't receive public funding, at least not in that sense. So none of the traditional prevailing wage triggers apply to what a receiver does. So we do not do our work at prevailing wage rates.
Okay, let's now turn to some examples of your use of the receivership remedy. And this first one, you want to talk about this one, Kevin or Greg?
Okay. So I can talk about this one. So this was the property at 3345 Madison Avenue. We call it the Home Depot house. We'll go ahead and flip to the next page, and it becomes pretty clear why. So for people that live in Riverside, this story was told for a long time, and everybody knew about it. Home Depot came into town years and years ago, well over a decade ago, and built this property. And they went through and purchased all of the homes on the street. There's a street there. It's Madison Street is the main one. It goes perpendicular to the freeway there. And they purchased all of the homes. And all of the homeowners except one agreed that they would go ahead and sell the home. So this last property owner said, no, I'm not going to do it. I've heard they offered as much as 3.5 times the value of the home. He still said, no, I'm not going to do it. So Home Depot built a wall around his property, and that's that part you can see the trees in front, and they built a very large wall completely around his property, and they developed everything else around it. And this took the property value from something that was a lot to next to nothing. We flip over to the next page. You can see what happened was eventually this home, the homeowner abandoned it, and this became a drug house. It was used by local gangs. It was every code violation you could think of took place in this home, but it was wrecked from top to bottom. Flip over to the next page. You can see inside they actually built an indoor spa in there. It wasn't filled when we were there, but that's on the table there. You can see various items used for taking drugs. And so when we got appointed, we were asked to come up with a plan to fix up this property. And this was a simple plan. Going over to the next page. Its highest and best use was demolishing the structure. So this structure that had been there for nearly 10 years, I don't know the exact number, but I'm fairly certain that police were called there well over 100 times to come in and arrest people and remove people from there. It is now a vacant commercial lot, and it's hopefully going to be developed here soon by a developer. So this was a fairly easy case for us as far as coming up with the plan, because this was the best use for it, and the court had no problem approving our plan.
And demolition costs ended up being paid out of the sale of the property?
And everything was. So we were able to, the buyer ended up paying the city back 100% of all of its attorney's fees, fines, and administrative penalties. They paid the receiver in full. They paid all of the demo costs under our supervision. We weren't discharged until that was done. And I believe they even paid the property owner a small sum as well. And so it was, as far as we were concerned, a very successful case, and it happened very quickly. From the time of our appointment to the time that this demo took place was a few months. Yeah. Greg will talk about this one.
Okay. This was really a very tragic story that ultimately concluded with an overall positive result for the neighborhood and for the city, but still very tragic for one of the occupants of the home. So what happened one evening is that the Riverside Police Department gets a call of shots fired. They respond to this home. The adult son in this home had shot off rounds from a rifle. Once they were able to apprehend him, then they found a very, very unsafe situation. Now, what you cannot see is that immediately to the left of this photo is California Baptist University. And the homes in that neighborhood, many of them were owned by Cal Baptist University and were used as off-campus housing for professors and staff.
Is that Adams on the left side?
Yes, Adams on the left, the 91 freeway at the bottom. And this is just a middle-class, single-family residential neighborhood. Most of the homes were built after World War II. So once the police respond and arrest the individual and are able to regain custody of the weapon, they then conduct a search of the home. They find a grossly substandard property. They find explosives. They find bomb-making equipment and materials. And tragically, they find his elderly mother horribly neglected and near death.
So they were able to render the home at least safe enough to clear a path to get the paramedics to his mother, to get her out of the home. She never made it out of the hospital and ultimately died as a result of her condition. The son, of course, was arrested for multiple felonies, and he was securely at our residence inn in the custody of the county sheriff's department. It was clear to us that traditional code enforcement was not going to be successful in light of the fact that the mother was incapable of assisting us and the son had questionable capacity and was in custody. It took the Riverside Police Department's Technical Services Unit 3 days to render the property safe. They had to bring in bomb technicians from the federal government, were flown into Riverside, and they had to evacuate nearby homes for up to 3 days. It was quite extensive, and what this individual had done is he essentially converted rooms into a bomb-making factory. And he had each component meticulously set up in the process by which a bomb would be made, mostly pipe bombs. So we moved immediately once it was safe, and what you see in that photo right there on the upper left, you see some sandbags on a table. Well, what you don't see is that some of the explosive ordnance was so volatile they had to create a pit in the backyard and create sandbags to actually explode it on site because they couldn't get it off site. So once that was all done, then, and what you see in the backyard is exactly what the house looked like. We then secured the property, we boarded it up, secured it. We did not proceed by way of an ex parte. We filed a notice motion for a receiver, went in, had the receiver appointed. The receiver was then appointed within 60 days.
Is this Kevin?
And this was Kevin and Nick. The home was rehabilitated and sold in less than 9 months. It was sold to a first-time buyer, a young couple that had recently gotten married. We were able to include a 25-year owner occupancy covenant in exchange for reduction in fines and penalties and some costs. The funds from the sale paid for the rehabilitation, the receiver, and the city's attorney's fees. It certainly increased the property values for the neighborhood quite significantly, and what we felt so gratified about is it served as a catalyst for neighborhood improvement. That the neighbors then, who were mostly owner-occupied residents, they took greater pride in their property, and we saw an increase, improvement in individuals, painting, landscaping. People were taking much better care of their properties and took much greater pride of ownership. And then we concluded all of this with an open house in which we invited the council member for the ward, the mayor, opened it up to the neighborhood, and that was the opportunity for the new family, the new owners, to meet the neighborhood. And it was a win-win for everybody. It was ultimately, we took a very, very tragic and unsafe situation and really made the best of it.
And another great example of, I'd imagine this property sat in an area that was otherwise on the upswing because of the expansion of CVU, Cal Baptist.
Exactly. This was a really nice middle-class neighborhood. So you can find these anywhere. And of course, no one knew the extent of the issues until he actually stepped out front and started shooting off his rifle.
This takes us to the Hoarder House. Who wants the Hoarder House?
I think that'll be me too. And I'll take over this one because this is the house where nightmares are made. We've actually done over 100 receivership properties since we've been doing this over the last 9 or 10 years, and this is the one that'll stick out in my mind as being the worst of all of them for several reasons. So we'll go over to the next page. You can flip over. So when we were called out for this property, what you can see is it's a duplex. What you can't see is that there's a little tiny driveway. If you look on the right-hand side, the bottom right-hand picture, you see a door is open. There's a driveway that's about 8 to 10 feet wide. Directly to the right of that is an elementary school. There's a chain link fence separating the elementary school from the property itself. when the city first was alerted to this property, they discovered that living inside of this home were anywhere from 10 to 15 people doing various bad things, and several of them were registered sex offenders who were living there. There were inside of the garage, they had set up a child's car seat that was hanging from the top of the ceiling, and it would just dangle there, presumably to put young children inside of it while the parents sat around a circle and did drugs. Inside the house, it was about as bad as you can imagine. If you flip over a few more pages here, well, this is the outside of the garage where the kid's car seat was hanging. We'll flip over to the next page. It's the backyard, just a small little area, and then one more. Kitchen, and then one more as well. So this is what it looked like. So when the door opened up for the first time, what you can't see in the pictures, you can't see the smell that came out of it. They had cats inside of it, and what they would do is they'd open up a can of cat food. They would feed the cat, and they would throw the can in the corner of the room. When we got there were roughly 200 cans sitting in the corner that had not been cleaned out. What you're seeing in the upper left-hand corner, those are cobwebs. Some of them almost as thick as ropes. There is a tree that's growing through the window, and then there is the bloody handprint that we, to this day, don't know whose it was, but we know it wasn't, something good did not happen here. When we took over this property, it was as bad as you can get. We came up with a rehabilitation plan to correct all of these issues. I don't know if the city could have named every single violation inside of it, but we corrected all of them. We ended up, after rehabilitating the property, we ended up selling it to a father who had his daughter living in the front, and he was living in the back while his daughter was in school. And it was fully rehabilitated. We were able to pay back the city in full, cover all costs for the receivership estate. And so this was a very successful property, but it certainly began as one of the worst ones that we've had yet. And so this is one where when we were done, we left the feeling of knowing this is the right program, and this is the best thing for the neighborhood, not just for the neighbors beside it who own the home, but for the elementary school kids that were playing on swings within 15 feet of what was going on in this home.
We also had a question, and I will take a shot at answering it and welcome input from everybody else, which is, what do you do if the property owner is in bankruptcy? And my understanding is certainly the first step before you take any action against the property owner is to seek relief from the stay. My understanding is it shouldn't be that hard to obtain relief from the stay, and then once you do, the process may take a little longer because of that additional procedural step, but you should not view bankruptcy as a hindrance or a reason to not pursue receivership.
Well, Nick and I both have experience with this aspect. We one of the cases we did with the City of Riverside, that was the owner's, that was his angle, and he actually found a lawyer who supported him, and that lawyer ended up being sanctioned $25,000. What he would do is he would file, we would get relief from the stay, he'd file an appeal in the bankruptcy court, or he'd try to file a new bankruptcy case. I will tell you, he was successful in adding about, 3-4 months to the process and some extra costs, but at the end of the day, we did get permanent relief from the stay, and we moved forward on that home, and his lawyer, who advised him, was sanctioned by the court. I think $25,000, Greg? Something to that effect? For abuse of the process? For abuse of process.
Yeah. Early on in Ontario, we had an attorney for a bank. What had happened was a bank had foreclosed, and that bank had become insolvent. So this matter was tied up in a bankruptcy court in Delaware, and we heard from an attorney, and that attorney said, well, you'd have to go retain local counsel in Delaware to get the stay lifted. And the subtext in his commentary was, and you won't do that because nobody does that. And Ontario said, oh yeah, and we did it. We went into Delaware, got the stay lifted, and so.
And we're able to successfully proceed.
Oh yeah, and the court was like, no problem. We see why you're here, and the stay was lifted, and I think we did that a couple of times. And the court, particularly in situations like where it's part of a portfolio, the court is very happy to let you exercise, to administer justice.
And thankfully, the Bankruptcy Code has a very specific section that allows a public agency to obtain relief from stay for public health and safety reasons. And so in our case, we got relief from stay. Ultimately, we had to get a court order from the bankruptcy judge ordering the debtor and his attorney not to file any further papers in the court.
And he used a word that reminded me of something. He used the word portfolio, and I think this is an important point to make for people out there to understand. We were talking earlier about how properties get into this situation, and one of the things we found is that a lot of times the loans on these properties are held by lenders in bulk transactions. So they get traded, the paper gets traded around, and so the existing lender has no idea that they have paper on a particular property, and so they, of course, aren't paying very close attention to their security interests. In fact, one of the things we discovered is that you would think that if a lender has a deed of trust transferred to them, that the first thing they'd want to do is get that deed of trust recorded so that they're notified if there's anything that comes up on the property, including code enforcement notices. And one of the things we discovered is that, in fact, they don't do that. What they instead do is they don't record their interest until they're actually ready to foreclose, if then. And so that's sometimes a challenge where the lender who is on title as the lender is in fact no longer the true lender.
And the other thing I think that happens, if you're talking about an institution that's buying a huge portfolio, they are buying that portfolio at a discount, and they fully anticipate that some of the assets will not perform, and therefore they will do nothing to defend their interests with that particular asset.
And understand that sometimes those lenders aren't just the lenders on the property, that they've now actually become the owner of the property. Right. And it's because of this sort of portfolio situation that we've seen that courts aren't having a great deal of an issue with appointing a receiver. Okay, what we're going to do now is, Sam, you're going to summarize some of the other civil remedies that are available, and then we're going to save the last portion of the hour for a roundtable discussion about implementing a receivership program with your elected officials and with your staff and with the public. So, Sam, why don't you go ahead and cover that, the other remedies.
Sure. So there are some times when you just can't use the health and safety code receivership because of the type of property it is or other considerations. So there's another possibility for bringing a receivership under the Business and Professions Code under Section 17200. Now, opinions vary on how effective this remedy is. For my 2 cents, I've used it effectively numerous times to bring a property into compliance. Here's when you use it. Go to the next slide. You use it for commercial properties which have extensive state and local law violations which endanger health and safety, but where the primary use of the commercial building isn't for human habitation. So remember, for the health and safety code receivership, you need a building used for human habitation. Where you have a commercial property that's not, this might be your remedy. Under 17200, it provides remedies for unfair competition. Unfair competition is defined as any unlawful, unfair, or fraudulent business act or practice, and unfair, deceptive, untrue, or misleading advertising. So for the purposes of remedying a nuisance property, you're going to look for the unlawful prong here. The theory I'm using this remedy is that any property owners have to keep their properties in compliance with state and local housing and building laws, and if they don't, they gain an unfair competitive advantage. And so they would be in violation of Business and Professions Code 17200. Amongst its remedies is appointment of a receiver under Business and Professions Code Section 17203. You can also get injunctions and civil penalties not to exceed $2,500 for each violation. But can we get attorney fees? Here's the rub. The Business and Professions Code Section 17200 does not provide for the recovery of attorney's fees. So that's a little problematic when we're talking about the kind of money that might come out for a receivership. You may be able to recover those if it's coupled with a nuisance abatement suit and you use your municipal code attorney fee recovery statute or ordinances. But it's not exactly a clear path. There are other restrictions too. It has to be a commercial property, obviously, because we're doing an unfair competition statute here. But here's probably the biggest hurdle. You have to have district attorney approval for the suit. And unless unless you can show two things. Either that you're a county council that has an authorizing agreement with the district attorney in actions involving violation of a county ordinance. So if that's you, then you can overcome this particular requirement. Or it's brought by a city attorney for a city with a population in excess of 750,000, which isn't going to be many cities. So you have to have district attorney approval before you can get it. And there are some places where the district attorney jealously guards his power. Well, they'll never get it, but there are places where the district attorney has a cooperative partnership with the city attorney or the county counsel's office, and they will give this approval, usually if they're on the pleading and can monitor it in some way. I've successfully used, in fact, on mobile home parks for the most part, and in fact, in one particular instance, we not only got all the fees back, but we got about $25,000 in fines and penalties for the city above and beyond the cost. So it can be used successfully. It does have its restrictions and limitations. Another remedy is the complaint for nuisance abatement. I'll go over this real quickly. This is usually for a property where the violations aren't tied to the building. Remember, the Health and Safety Code requires that it be tied to the building in some way. And so this is sort of your junkyard property, or maybe for minor violations that are bothersome but aren't necessarily rising to the level of health and safety concern. So under Code of Civil Procedure Section 731, civil action may be brought in the name of the people of the state of California to abate a public nuisance as defined by Section 3480 of the Civil Code by a district attorney, county council of any county in which the nuisance exists, or by the city attorney of any town or city in which the nuisance exists. So most municipalities, almost every one, will be able to use this, talking about counties and cities specifically. So let's look at the definition for nuisance real quick. Under California Civil Code Section 3480, a public nuisance is one which affects at the same time an entire community or neighborhood or any considerable number of persons, although the extent of the annoyance or damage inflicted upon the individuals may be unequal. It's pretty broad, and I will say the government code allows municipalities to define nuisance themselves, and most of them do. So you can also use your local entity definition for nuisance, which are pretty expansive to meet the definition for a public nuisance as well. And in fact, it's probably the better set of statutory authority to use. So when to use this tool again? For properties with extensive state and local law violations which are not connected to the building or property. For commercial property which is not used for human habitation, or if it is and you just can't get district attorney approval, or you can't use 7200, for example, then you would go ahead and use this remedy. It can also be used where the nuisance isn't necessarily how the property is maintained, but is repeat criminal activity, which drains the resources of a jurisdiction, or a property that's a hub for drug activity. So we'll go to the steps really quick for a nuisance abatement. They're the normal steps for most any complaint. You'd file a civil complaint for nuisance abatement. You'd make use of temporary restraining orders, preliminary injunctions. You'll mainly use those if there are violations which pose an immediate danger. Again, this would probably be on the outside of the property. You resolve it through summary judgment or trial or settlement. And the goal would be to get a permanent injunction. Now, just because you have the permanent injunction, that doesn't automatically mean the property owner is going to comply with the order to clean up the property. So you might be in enforcement land if they won't. So the main tools for enforcing are contempt and appointment of a receiver. So contempt is not my favorite remedy for enforcing one of these orders, because usually you have to come back multiple times. There you're talking about fines, maybe jail time if you bring them back many times on the contempt. But I find that when we're talking about cleaning up the property, the court's very hesitant to really lower the hammer on them to give them chance after chance. What might be better is a remedy under the Code of Civil Procedure for appointment of a receiver to carry out the judgment. So the Code of Civil Procedure provides for that. You'd have a receiver appointed to enforce the judgment, and you would want to ask for the same powers for the receiver that you would ask for on the Health and Safety Code. So how about collection of attorney's fees for nuisance abatement suits? Nothing in the Code of Civil Procedure is civil code, but usually probably your jurisdiction, your municipal code scheme has something for recovery of attorney's fees. The problem here is that you're going to be, even if you get an attorney's fee award, collection can be a problem. You're going to get a judgment, and then you're going to sit in priority behind everybody else who's recorded against the property, and usually there are judgments and other things for these types of properties. So you have no guarantee of payment unless the property's sold or it's refinanced. If it's property with a lot of equity and you're not too far behind in priority, then you can go get a writ of execution and sell the property. So it's a possibility of recovering those fees, but it's less certain than in a receivership, and certainly not as quick. The last thing I'm going to talk about are two different species of nuisance abatement suits. So sometimes the nuisance is not so much the way the property is maintained, but it's the fact that there is constantly crime at the property. The nuisance in this case would be the criminal activity, and the key here is you would have to have a lot of evidence for this in advance of filing. So you need to gather tons of evidence of the criminal activity, the kinds of crimes that have gone on there, the number of calls for service that it generates, and that kind of thing before you could file. And it would need to be fairly extensive to show a pattern. One or two instances is probably not enough to constitute a nuisance. And also, before you file, you should have in mind what the remedies are going to be to address the criminal element there. Because the court's going to look to the municipality and say, what do you want the property owner to do? I'll give you a judgment. What do you want? And so some of the things you might ask for, security gates, cameras, professional management, change in the hours of operation, maybe the liquor license is a problem, maybe you need more bouncers if it's a nightclub or something, or other place. The point is you need to have an idea of what's going to curb this so that you can ask for it from the court if you want to be effective.
Sam, Greg has a comment on this particular remedy.
Another thing to consider is that, especially when you're dealing with criminal activity, is that you may be able to reach an agreement with the property owner such that you do not pursue the receivership remedy. They agree, they stipulate to a permanent injunction, and then they further agree, which we did in several cases, where if they violate the permanent injunction, then they, through this agreement, have stipulated to the appointment of a receiver. So the only issue is whether or not they violated the permanent injunction. Once we prove that up, then they've already stipulated to the appointment of a receiver, and then you move forward. And that's exactly what we did in one particular property in which we had parents who own two duplexes. They live in one, and then the drug-addicted sons live in the other and are in or out of jail and are engaged in criminal activity. And so they stipulated to the permanent injunction at the time that their sons were in jail, but once the sons were back, they allowed them to stay there, and of course the criminal activity resumed. We were able to prove that up through work with the police department and the neighbors, and then ultimately we were able then to prove up that violation of the permanent injunction. We were then able to have a receiver appointed. We then rehabbed it, we sold it, and there was no longer a place for the sons to live. Problem solved.
Okay, Sam, do you want to talk about the last remedy then?
Sure, really quickly. Sometimes the nuisance condition on the property is repeated drug activity. I'll be candid with you. Most of the time, when we're talking about drug activity in the property, you're also going to see the health and safety violations. I would say almost always, but I guess we're talking about the drug dealer with pride and ownership here. Sometimes there's not any violations. It's just the drug activity itself that's the problem. So under the Uniform Controlled Substance Act, it says every building or place used for the purpose of unlawfully selling, serving, storing, keeping, manufacturing, or giving away any controlled substance, and every building or place wherein those acts take place is a nuisance, which shall be adjoined, abated, and prevented, for which damages may be recovered, whether it is public or private nuisance. So really, this is just another species of nuisance abatement suit. So you'd have the same kind of remedies, your injunctions, your temporary restraining orders, preliminary and permanent injunctions. It does, however, have some special remedies. You can get a closure order both pending trial and for a year after trial. And that's probably the best remedy for this kind of thing, is you can get an actual order that everyone's vacates the property and it's boarded up. I've used this a couple times to board up the property, and you find that they move on because now they've lost their base of operation, and hopefully end up in jail at some point before they come resurface in the city somewhere else. But it's a tool that can be used when you can't make the other tools work. Also provides for civil penalties not to exceed $25,000, recovery of costs by lien. Again, no attorney's fees statute for this particular statutory scheme, but you might be able to get them through your municipal code for a nuisance.
Okay. So let's conclude with a discussion about some of the issues surrounding the civil remedies, in particular the receivership remedy. I'd really like to get, since Greg and Andy, you both work for agencies that were successful at implementing not just a one-off, one-time type use of the receivership remedy, but an actual program. And I'd like both of you to address how you were able to do that in Ontario and in Riverside.
Well, at the Riverside, education and buy-in were key. There's likely to be resistance based on a sense that this remedy is too extreme or too aggressive, and it interferes with lawful property rights. So the judicious use of this remedy as a last resort is really critical. So what we did is we went to the City Council in open session, and we brought the remedy forward to them. We educated them, and we sought their direction as to the criteria by which they would be comfortable in us using this remedy as a last resort. So we were able to establish the program with the elected officials' direction and guidance. So we established that criteria. We established a policy or parameters when the remedy may be used consistent with our city's values and priorities. From there, we decided to start slow, but we would start with the worst of the worst. Because what we wanted to do was to get some early successes to show first that staff could use this remedy judiciously. So we put together the worst of the worst cases with code enforcement. We went forward on a case-by-case basis, brought the matter to the City Council, and they authorized us to initiate the receivership. So we started slow. We kept them apprised of our progress. We reached out to the neighborhood to let them know what we were doing. As soon as the receiver was appointed, we put up a huge sign in the front yard to let them know that this was a neighborhood rehabilitation project that was not paid with taxpayer funds. Rather, it was paid for by the property itself. And we met with neighborhood groups and kept them apprised of everything that we were doing and gave them a timeline by which this property would be rehabilitated. And that was very, very important to gain the neighborhood support. They also were our eyes and ears during the entire rehabilitation process. And then what we did is that we made sure that we celebrated our successes. So as indicated earlier, with each successful rehabilitation, we had an open house, opened it up to the neighborhood, brought in the new owners, brought in the elected officials, and celebrated the success of the rehabilitation of that property and the elimination of calls for service. What we also did is that every 6 months, the City Attorney's Office made a presentation as part of our Neighborhood Livability Program to the City Council in open session on the discussion calendar, whereby we updated them on our progress over the previous 6 months. And receiverships were just one component of that overall program. And we showed them the before and the after. We showed them the pre-rehabilitation per square foot value, the post per square foot value. We showed them what money was recovered, how it was paid out, and neighborhood groups and neighbors would appear to share their thoughts regarding the program, and it created its own momentum. And so by starting slow and getting some early successes and getting the elected buy-in, and then of course there's the education of the judicial officers. That took quite a bit of time to educate our bench on the remedy and that we were using it judiciously and that each step in the process the court would be issuing an order. So all of that collectively led to a very, very successful program. And once it started, the elected officials were very supportive, and they and their staff would look out for properties that we could now put into the program. So, Andy?
Ontario was a little different. We started off with what I would just call a fairly straightforward building code enforcement approach to some really high-profile problem properties, lots of calls for service, we had a 200-unit apartment complex that the city was prepared to basically use all of the discretionary housing dollars they had to consolidate ownership. The city was basically prepared to spend $12 million to fix this and address this problem. And, you know, using code enforcement and the threat of demolition, we solved the problem for probably a cost of about $250,000, most of which was city attorney's fees that we weren't sophisticated enough at the time to think about recovering. And the council was so impressed with that effort that it snowballed from there. The other thing that happened was we were consistently taking down and out, you know, localities and properties that were sources of lots of calls for police service. So the other thing that we call it, we were eliminating criminal habitat left and right. And so code enforcement began to enjoy a really excellent working relationship with the police department. So that's how it happened in Ontario. The elected officials saw the investment, they saw things getting better, they saw how code enforcement was saving money for redevelopment agencies and housing agencies that could be used in different places. And then the single family homes that we rehab, we never had any resistance at all. So I can't stress enough the elimination of criminal habitat as being a real benefit that is broadly supported by the community.
Thank you, Greg and Andy. I think you've both sort of addressed both the first point, which is how to implement the program, and convincing your electeds. Let me just open up for anything else any of you would like to share about the overall benefits of a successful receivership program, of course, including Kevin and Nick. You've shared some things. Anything else you guys want to share about just the benefits of a successful receivership program?
Just a couple things. First of all, and going to Andy's point, is that it really caused us to work as a team. It did create new relationships between our police department, fire department, city attorney's office, code enforcement, building and safety, and our economic development group. It really was, and our housing authority, it really was a complete team effort. It really allowed us to use existing resources. There was no necessity to hire up staff. We were able to work really well together, and I think that was one of the real values that came out of it. And then, of course, the other was those neighborhoods that were teetering, those neighborhoods that they could flip one way or the other. And we could bring to bear all of the city's resources and then make sure that that neighborhood didn't fall the wrong way.
Yeah, and Nick and I talked about this in the break, and I think we both saw this in Ontario and Riverside. A lot of rental properties will be woven into the fabric of single-family neighborhoods. And once the word got out in Ontario that this is what Ontario was going to do if you did not follow our directives, for every one receiver we saw appointed, we were probably having between 25 to 30, maybe 40 substantive rehabs. And I don't mean paint and carpet. I mean, if you needed a new roof, there was a new roof. If the sewer lateral was, whatever it took to bring this property back online. So property owners under the threat of receivership were spending tens of thousands of dollars to rehab their own properties. And, once we compel you to make that kind of investment, now you as a landlord are going to, pay attention to that asset more closely moving forward. So, significant.
And from a receiver standpoint, obviously when it's in a community where I live, that's something I care about deeply. But one of the things that Kevin and I decided very early on was that we want to do this long term. And in order to do that in a community, in order to do that before judges, you have to have a long-term strategy of how am I going to treat not just this case, but what are my actions now and how is that going to impact me the next time I'm before this judge. And so what we have developed now at this stage is that I would say 90% of our motions are now stipulations. We know exactly what's going to happen in the process from start to finish. We are open and transparent with everybody from the very beginning, and because of that, we're able to get parties to sign joint stipulations. What that's done is that when a court sees us come into court, they don't think that this is going to be a headache. They don't expect to see us very often. They want to see us every 5 months for a status conference, and that's it. They don't want to see contested motions. They don't want to see appeals, and they certainly don't want to see a receiver coming in asking for contempt and others. So having that long-term strategy, I think, has paid off very well in that we're able to do these in a fast, efficient way and in a way where courts are excited about seeing us because they know that we're going to get this done quickly. And so I think that helps from a receiver standpoint.
I also just want to talk about one other thing, and Sam, maybe you can talk about this, because you started doing these cases in Southern California, and then you relocated to Northern California. Do you have any comments on if you're, because we may have some folks that are in counties where they don't see a lot of receivership, and do you have any thoughts, Sam, or anybody else, on persuading the local courts to buy into the remedy? Sam, have you had some experience with that, with courts that are seeing the remedy for the first time?
Sure, I've kind of pioneered that process up here. You know, because some jurisdictions haven't seen it, there's sometimes an education process, and that is that sometimes we have to go in front of the court a couple times to give them some comfort with the remedy itself. But I find that's where the experience comes in, because I've done this a number of times. You know, I know exactly how to put the court at ease in terms of the process, and the best way you can do that is having good receivers who can sort of walk them through the process at the appointment hearing, and then explaining to the court exactly from A to Z how this is going to go, how everyone's going to be paid, and what process are going to be done. And that experience really is invaluable, I think. You know, in terms of the overall benefits of a receivership program, if I could just add in, you know, one of the things I love about this remedy is just seeing how grateful the neighbors are, because a lot of times when the city council learns about this product, it's because the neighbors are coming with pitchforks and torches about a property that's been a problem for a long time. And once the receiver gets in and works his or her magic, the level of gratitude in the community is huge.
The only other point I would add is that as far as educating the judiciary, is that we faced resistance at the outset. And the judges were not familiar with the remedy, and some of them actually viewed the remedy as too extreme. And they were not prepared to use their equitable powers. So it goes back to some of the points that I made earlier, and that is you really need to go after the worst of the worst first. You have to educate the court through the worst of the worst to let them know, so the court is clearly understanding that they would feel threatened if they lived next door to this property, and they would want the city taking this action. You also want to make sure that you have proven to the court that this is truly a last resort, that you've exhausted all other reasonable means, and that you have been forced to pursue this remedy, or, as in the case of the bomb house, that traditional code enforcement would not be effective and it would not protect the residents. And so I think you need to start off in that manner and build the credibility with the court so that they know that when the city of X or the county of X steps into court and is seeking this remedy, then they are doing so because they have to. And I think that's really the point. If you try to use this remedy where it shouldn't be used, then you're going to harm yourself for future receivership projects.
So that takes us to the top of the hour. I want to thank each of our panelists. Everybody has made amazing contributions to this. It's been a great discussion. I want to thank everyone for joining us. Everybody that's a member of this panel thinks very highly of this remedy. If you have further questions, you can send them to events, E-V-E-N-T-S, at bbklaw.com, and we will make sure that one of our panelists contacts you and attempts to answer your questions. Also, if you have further interest in more information about this remedy, feel free to contact one of us. If you're interested in, for example, meeting specifically with a receiver to go over the properties that might be in your city, I'm sure that Kevin and Nick would be happy to talk to you about that. So take advantage of contacting them. And I think on this panel are some of the most experienced professionals with the receivership remedy, and we need to be happy with answering any further questions you have and talking about specific properties that you might have in your jurisdiction. With that, one other thing I wanted to note, the last page of the presentation, we did, for those of you tuning in from out of state, we did provide some examples of out-of-state authorities with a similar receivership remedy. Kevin and Nick put that together. So that's there for you also, the last page of the handout. And with that, I want to thank everybody for attending and wish you all a great afternoon.